So hello everyone, and welcome to our colloquy for week 9, and we're going to finish off today on contract theory. Next week we will continue with agency, and then we're going to break for 2 weeks. After the break, actually at the beginning of the break, I'm going to issue your exam briefing, important document, and then I will take you through some examples of what I need you to do for part B of the exam. So today we're going to continue with equitable remedies. As we said in Springfield this week, a remedy basically is what we call the objective under the Wentworth-Miller method. So it's basically what you want. Is it going to be a right that you want to enforce, or there's a loss that you want to correct? We talked about different types of law of contracts. One of them is the B2B or consumer law, B2C, which means that there's a business that's selling to a consumer. Under that, of course, now today, it's mostly governed by the ACL. And as I said, I've mentioned a few times the ACL in your textbook. I expect that to be part of your notes going to the exam, all right, for part B. And it has 2 different types of guarantees, either for minor or major failures. If it's a major failure, just like under common law, you could reject the goods, basically you can cancel the contract. And if it's a minor one, you could get some sort of damages or replacement and so on. If it's a B2B contract or a non-consumer contract, we still talk about things like conditions or warranties or indeterminate or intermediate terms. And these, of course, decide again whether you can cancel the contract or rescind the contract if it's a condition, meaning that it's a very important term in the contract and it has been breached, or if it's a warranty which is of lesser importance, and that means that you have access only to damages or compensation. So we said in Toowoomba that we have a full suite of different remedies. So when you look at objectives, you have also to think of what does that mean in legal terms? You know, objective meaning what? What am I going to go to court and argue? Of course, there's a very important decision coming down at 2:15. Do you know that? The High Court of Australia is going to come out and talk about the SSM, and there will be just a brief outcome, and then they will give us the reasoning later on. So we're really looking forward to that. We'll see. Now, so this is what we talk about in terms of remedies. We said in common law you can have access to damages, meaning compensation, or you could have rescission and restitution. We talked about that in Toowoomba. Today we're going to flesh that out a bit more under equity. So rescission and restitution are still available under equity, but they are more flexible. Okay, we try to remove the hard edges that come with common law. So you find that rescission under common law, which is this part down here, under common law, it has to have something called restitution in integrum. So it has to be complete return to your pre-contractual position. That's not a requirement under equity, all right? Just remember that restitution and rescission are available for defects in the contract, not where there's a breach, only where there are defects. Defects that we talked about earlier include things like what? Whether the contract is valid. So we talked about things like capacity. We talked things consent. We talked about legality. Okay. So that's when these 2 things are argued in objective. Whether you want to cancel the contract or you want to get compensation under rescission or restitution. There are also other things. So these are also available under equity, but equity extends your possible remedies into things that, of course, all of which are under the discretion of the court, that include things like specific performance. Okay? So here, you don't want to cancel or to get compensation. You actually want the stuff that you agreed with the other party on. Again, that bloody pen. I want to sell the pen to Bill, and Bill really wants that pen. So he would go to court and ask for specific performance. I want the pen. See, maybe it's a very valuable sort of collector's item or whatever. Yeah. So you want actually the other party to do their part of the bargain to make good on the promises. All right. The other thing that we have is what we call injunction. Now, when we heard about injunction, we talked about nuisance, if you recall. A nuisance was what? An indirect, not a direct like trespass, indirect interference with your land rights. So we said there you can go and ask for an injunction. Stop, don't do this anymore. Okay, so it's a court order basically restraining this other party from breaking their contract. Okay. Now there are also things called Moreva injunctions. So this is a freezing injunction, and it relates to things that have to do with assets. So you're trying to prevent the other party from, for example, sending their money overseas or sending their money to a tax haven. So you can't actually get that money back anymore. Okay? There's also the Anthem Pillar court order, and this is really about IP in the sense that it is going to give you the right to search their data so that you can find some evidence that supports your cause of action. Okay? Court order to restrain a party from destroying evidence where there is a prima facie case of breach. All right? And then there's the last thing, which is quantum meruit. You remember we talked about quantum meruit last week. One of you asked a question as well that maybe I will also expand a little bit on. I think it's a very good question. I like it. So it says in cases of part performance again, and where there is no fixed remuneration, you can get a court order for payment of a reasonable amount for services given. So this is basically going to look at what the market value of what you have performed is going to be equal to.
So is that what I haven't done?
This is what they have. Quantum meruit is what you are going to be paid for what you have done. But, so for example, if you have done some work for one of the, if you are a builder, say, okay, you have done work under a building contract, and the building contract says that you're going to be paid at the end. So it's not actually one of those contracts where you would get paid at certain intervals, so it's called a divisible contract. It's not a divisible contract, okay? So, in that event, you wouldn't be paid until you have completed performance. Now, let's assume you couldn't do so, for whatever reason, not maybe your fault, okay, but you couldn't, okay? Maybe there was frustration. Would you still be able to get paid for that? And the answer is yes, provided that you can argue this quantum meruit. That's good enough. So you would be able to argue quantum meruit. So you are not allowed to be paid under the contract because it's not divisible, but that's not the end of the world. You can still go and argue quantum meruit under the court's equitable jurisdiction, out of justice. Yeah? So they might be able to actually pay you for the work that you have performed. All right. What are the remedies for breach of contract? So this is what we talked about on Monday. We said that under common law, you would get mostly damages. So that's what we call monetary compensation. But you can also get rescission. So you rescind the contract, meaning you cancel the contract. I don't want to be part of this contract. So you remember when we talked about minors in certain places where they have this idea of making the contract voidable? That's the whole idea here, okay? You rescind the contract. So you have that right to be able to say, I want to cancel the contract, or restitution, which is also about compensation. So you could be compensated under that idea of restitution, which is based on something called unjust enrichment. And quantum meruit is the same way. So we'll talk about quantum meruit a bit more. So let's just dig in and look at equity in terms of these remedies. Okay. In which situations may an equitable remedy be used? Okay. Now the first thing I want to remind everyone again and again is that this is at the discretion of court. Okay. More likely than not, if you go to any courthouse and there's proceedings and they want to argue something at court, they will never start with equity, because it's at the court's discretion. You don't have that power or control over them to do something. It's up to them, out of fairness. So you have always to start your arguments with common law. But in the case where common law is not going to work, it's going to fail, at least I will have a plan B where there is, out of fairness, please, at your mercy, look at these things. The funny thing about that same-sex marriage, if you have been following, they talk about the Solicitor General's arguments, and I understand the first one they came up with was standing. Standing, meaning that the other side, Wiki or whomever, Andrew, whoever brought that other, who brought actually the action to court, they don't have standing, i.e. they're not affected. So they don't want to actually, they don't want to get into a same-sex marriage. So why should they come to court and talk about it? And this is strange because usually you start with the strongest arguments. You don't start with the standing. Today has been expanded so widely that you can't go and argue it's only because you are gay that you can come and say I want to talk about this. It affects everyone in society. So this idea of standing, a very strange idea to start with standing by the Solicitor General. And this is like the second, yes?
If he's a Solicitor General, that means that he's an elected representative, so therefore isn't he able to stand up there as a
So you don't understand the argument. He is arguing that the other party doesn't have a right to bring this cause of action to court.
Yeah, that's where I was kind of like a little bit confused because it was like the...
Yeah, I know. This is the Commonwealth Solicitor General. Why would you start with standing? So we use equity only after we've exhausted this idea of common law remedies. If I cannot get enough money from common law, I would go and see if I can get something from equity. If the court's going to give you enough money, they're not going to look at equity. Okay? So if damages are enough, that's the end of the story. So you have to start your argument by saying, yeah, I know I've asked for money, but the money is not going to be enough. So I want more. More like what? Specific performance. So here the contract, okay, for contracts other than for personal service. Okay? So you want to compel the defendant to perform the contract. Injunctions, as we said, to restrain the defendant from breaking the contract. Two types, the Moreva and the Anton Pillow. And then you have quantum merit, where the performance is going to be, there were part performance by the plaintiff, so the builder, for example, and they can apply to court for recovery of reasonable amount from the defendant. I strongly encourage, yes?
So that would be so the defendant would take the plaintiff to court because they didn't do their job, and then the plaintiff can say, well, I couldn't do it because of certain factors.
No, it's the other way around. It's the other way around. You are the plaintiff, you are the builder,
yeah. You
were not paid. So you're taking the other side, the other party saying, I did work for you, which enriched you, you got benefit from it, but you didn't pay me for it.
So how would that be, I'm just trying to get how you would get to that after the common law. So, like you said, you've got to go to the common law first.
So,
wouldn't the damages be enough to cover that?
So how are you going to get damages though? That's the key point. Where are the damages going to come from? So that's a good point. Let's just unpack it a bit more. So Michael is saying, I want damages. How are you going to argue for damages under this contract?
I did my work, or I did some of the work.
Yeah.
I couldn't finish the work because of some type of
So we always go back and say what? You have to look at the parties and the premises. What's your premise? Which area of law are you going to argue for damages under? It's going to be contracts, right?
Okay.
To be more specific, you're going to argue breach of contract.
Yes.
Okay. Was there a breach of contract? That's the point. The point is...
Yeah, but I may have been the one that breached the contract because I didn't do the job that I was supposed to do in the contract.
There could be something like that, so the fault is on you. Yeah. But I'm arguing, let's move that out of this picture. Let's assume that it wasn't your fault. Okay? Something frustrated the contract. So it was an unforeseen event outside your control or the other party's control. But for whatever reason, a certain point, you couldn't continue with the contract. Now I'm telling you the contract is entire. It's not divisible. So you can't go and say, I've done milestone, which is the case today. No one is going to sign a contract unless it's actually divisible. But let's assume that it's entire. So I will not pay you until 100% complete performance. You haven't done so. So I'm not going to pay you anything. That's when you would go to court and say, I want to be paid. But how could you argue damages? Because under such a contract, you don't have the right to be paid. The terms of the
damages would be zero.
Because it's 100. Okay. That's the one. Because you get zero damages. So I said this is going to be not adequate, you know. Then you would go and argue under equity. Okay. So I will say a few more things about quantum. We're going to go through some examples. Okay. Let's just quickly talk about these. I've given you, of course, the course reader or the textbook references, but just quickly, we're going to say under rescission, it says unlike common law, restitution, okay, restoration rather, in its entirety is not a requirement. We said under common law, it has to be possible for you to reverse back the contract because you are doing rescission to the point where the parties are restored completely to their pre-contractual position. Sometimes that's not possible. Okay? If that's not possible, you can't go and argue it under common law. But you can still argue it under equity. But now it's under court's discretion. So the court might say, actually, it's going to be difficult, for example, maybe to supervise such an arrangement. So, but that's the point. Under equity, it will help you to go beyond where the common law says no. Maybe there's something we can get under equity. So it's this idea of maybe. Okay. So the basis for such rescission would include things like the innocent misrepresentation and mistake. Now remember that we said that some mistakes would, this is very useful information, some mistakes would make your contract void. And in that case, that's where, of course, if it's void, it's void. But if it's voidable, that's where you would want to use rescission to cancel the contract. So you get to exercise your right under a mistake. Now go back and revise the different types of mistakes, and you have to really know which ones are going to give you void and voidable. Very important and very useful information, all right? Restitution. Where the money or property wrongly in the possession of the defendant is traceable. So, you have given something to the defendant, even possibly a deposit, and it's important that you are able to trace that money so you can get that money back. That's what you're trying to do here. You're trying to get compensation. Okay? So it comes in the form of what they call constructive trust. Okay? Or what they call equitable lien. Okay? Now we haven't talked too much about trusts or liens. Okay? You'll find more information about liens if you go back to chapter 23 under torts. Okay? You'll find more information about when a lien would arise. Don't worry too much about it because these kinds of instruments are really under equity. I want to teach you equity per se here. Okay? So if you do an equity course, they will teach you more about these things. Now the constructive trust means that it arises automatically. It's not something that you have signed or agreed on. That's why we are, so it's construed. Okay, so it's the idea that we are going to interpret the situation as a trust. As a trust, which means that you are the beneficiary of that trust, which means you get the money back from that trust. Okay? We don't need to go beyond that in terms of these two constructs. You just need to know that that's what's happening here. Things called trusts, something called constructive trust, and the other one is called a lien. Specific performance. This is used for information. Court order directing the defendant to carry out their obligations under the contract. So I'm telling you, I want something. And I want it from you, so I've agreed with you on a contract to exchange this thing, like a pen, and I want that pen. So I go to court, not asking for damages, asking for specific performance. Usually used if damages are unavailable, like the builder there, or inadequate. Court has to supervise the implementation of the contract, and we'll look at some examples. Then we have the injunctions, and we said that this is a court order, okay, restraining the defendant from breaking the contract. Again, it's only where the damages are not adequate, okay? And there are certain types, including Mareva and Tempiller. So Mareva is mostly about being able to freeze some assets that the other party might decide to send overseas, so you can't actually get hold of them. Or it could be an Tempiller, which is a search order, so you can go and search sort of, someone's hardware and someone's software for whatever information that could constitute evidence against them. In reality, of course, evidence is the hardest part of the legal process. That's where you usually fail. And that's where you usually see that the other party is going to try to poke holes in your arguments. And actually, evidence is the hardest act. Evidence law is usually the hardest to be able to grasp or get your head around. So if you're going to go and take the exams for becoming a barrister, you're usually going to fail that exam, and you're going to have to do it the next time around, because you have to have 4 exams, and you're not going to be able to do them all in one go. Anyway, quantum merit. Action for payment of reasonable value of services performed. That's what we were just talking about. So this arises where the contract is frustrated. So I think that was the question you've asked last time. Or made void, or terminated, or otherwise unenforceable. Okay? It was fibrosa, wasn't it? We'll see. Not available to the party who is in breach. So again, you can't be at fault and then go and argue out of the just, jurisdiction of the court that please give me money. All right. So let's look at these things again. We said, when it's going to be available. So it's at the discretion and where damages are not adequate. And we looked at these already. So this is the last thing I want to talk about. Just like when we started talking about cause of action in tort, this is similar statutes of limitations. So always remember, whatever cause of action you want to bring to courts, it has an expiration date. You can't wait too long. So for example, I know that there were defamatory events that occurred, say, on the 8th of April 2017, then I know, because defamation, I still have until the 8th of April 2018 to strike, meaning to take someone to court. It says, requested to control your camera. Okay. No worries. I think because they can't actually access the thingy, maybe I'm not sharing the correct screen or something. That's why. Okay, let's try this. Sorry, Andrea. Let's try to see if we can go back and put this through. That's why. Okay, sorry about that. So I'll just quickly go back and show you what we have been doing. Sorry, folks. So we're just saying that we're talking about these equitable remedies, and we talked about what we said last time in relation to what remedies are, the difference between consumer and consumer law. And then we said we have these different types of remedies under equity. We were just going through them, and we explained what would be required for an equitable remedy. We said that it has to have the fact that damages are not adequate, and then that triggers this idea of accessing these equitable remedies. And we said that these equitable remedies include these ones here, including the reference to your textbook at the bottom of each pillar or each column. And then we were just now talking about these limitation periods. So just saying where you would have defamation cause of action, you would have 1 year to bring that to courts. Okay? You can leave it till the very end, that's fine. It depends, of course, always, because the court is going to inquire. And you have to explain why you waited until the end of the limitation period. But if it's beyond the end of the limitation period, then you can't bring it. And some people were caught by that. I know personal stories. They went to lawyers, and the lawyers were negligent in the sense that they never checked when is the deadline for them to bring the cause of action. Same thing applies if it's a contract. So you have two different sort of expiry dates. If it's a simple contract, it expires before a deed or a formal contract under seal. So you can see that if it's under seal, okay, which doesn't require, of course, consideration, and it doesn't require any specific form because it's under seal, that could stay even longer. It's double almost. So if it's 6 years for simple, it's going to be 12 years under deed. So if something happens under a deed and you want to bring a cause of action, you have 12 or 15 years to bring that depending on the jurisdiction you're in. If it's a simple contract, you'll find that almost all of them are 6 years except the Northern Territory, which is only 3 years. Don't lose hope. If you're in Broome with a white set, you're going to end up in Northern Territory, so it's going to be only 3 years for you. I don't know if that's better or worse, but that's what they're talking about at the moment, if you're a liberal at least. Okay, so that's what we were talking about. That's the end of our colloquy, and I will just have, so all right, we're going to go now and look at some examples of these equitable remedies as we see them discussed in chapter 16. So the starting point is going to be on page 439, 29 rather. And let's look at Williamson, J.C. Williamson. So on page 430.
150.
430. So the facts are as follows. J.C. Williamson entered into an oral agreement, okay, with Colloquy and Mulholland, giving them the exclusive right to sell suites in his theater for 5 years. Okay. Again, under the Statute of Frauds Act, such an agreement had to be evidenced in writing. Okay, so they keep saying agreement, agreement, agreement. What they mean is what? Contract. Because now we are not lay persons, at least anymore. We know there's difference between agreement and contract. Agreement is only one element of the contract. They're talking about a contract. What happens if you need the contract to be evidenced in writing, but it wasn't? The defect, so we know that the contract is defective, and the defect goes to validity. Remember the seventh element, form? We're saying there's a defect in this contract. So what could that defect cause? What could happen? It could either become void, or it could become unenforceable. All right. So, Statute of Frauds says evidence in writing. There was no note or memorandum ever made of the agreement. This is back in 1931. These things don't happen anymore. You never know. You really never know. So after Colloquy and Mulholland commenced business, Williamson repudiated the agreement. What does that mean, repudiated? Yeah, so what did they do? There was some form of conduct that gave them the impression that he doesn't want to go through with this contract.
He didn't sell any suites at the theater.
For example. Okay? Okay. If this was an exam question, what would be the legal issue here? Yes, Alex.
Whether the contract exists or not in a written form.
Yes, we know that it doesn't. So that's not an issue. Remember, what is an issue? How do you know what the issue is? There's tension. I could argue one thing, you could argue another. That's where you have an issue. So someone else has to decide.
They can leave the contract and render it void or not. Because we want to repudiate anything if he pulls out, even though they agreed on it. So breach of contract.
It could be a breach of contract. So again, you know the premise is contracts. But where is the legal issue? Now, how do you find the legal issue? We said that you start from the elements. So you go through the existence. Is there any problem with existence here? Does the contract exist or not? Yes?
Well, they would want him to perform what they've asked.
Okay, but let's get to that first. Let's look at the elements. Is there an agreement? Intention? Consideration? No problem? So never ever waste time talking about those things when you answer the exam. You just say one sentence on the facts. There is a contract, so there are no issues in relation to agreement, intention, consideration. Done. Four other more. So we start with capacity. Is there any problem with capacity here? No. Consent? No. Illegality? No.
Well, because under the statutes of frauds, it has to be written.
Okay. So does that go to illegality? Does that make this contract illegal or something else?
It just means that it doesn't make it illegal. It just means that it isn't really recognized in the courts.
So is there a problem with illegality? No. So what's left? Form. The problem, procedural. So the problem is form. Okay. Is that then an issue here?
Yes.
Okay. So you want to ask yourself, what is going to be the effect of this defect in this contract? The fact that it doesn't meet the requirements of the statute of frauds. Is it going to become void? Is it going to become voidable? Unenforceable? What's going on? Yes?
Another problem it's going to have is that it won't have smaller little things in there as well. Like if you just say, oh yes, I want to sell things there, then what about things like, okay, what about the price? What about if the item is defective and therefore needs to be pulled or what if something like that?
You don't need to go there. It's very simple. I'm just trying to get you to do things automatically in the exam. So when you get yourself stuck, you know what you need to do. It's not just going to sit there or just try to bullshit yourself through it. I'm just going to write. No, take your time and do it this way. And then, of course, because we said the Wentworth Miller asks us to do the objective. What is the objective now? So that's the point you were making about they want actually to go through with the contract. Can they? That depends on what you will find under form, i.e. whether the contract can still be enforceable or not. Okay. They formulated their issue this way. And remember always that in the exam, your questions are not going to have only one issue. So for every issue, you have to do ILAC. Issue 1, law 1, application 1, conclusion 1. That's the first issue. Then you have to go and do it again for the second and the third and the fourth, God knows how many. Okay?
So we just have to register that like a pilot
Correct.
and do it.
You must, please. Because if you don't, your paper is going to come to me and God knows what's going to happen.
So you say the issue is this, the law is this, that.
Yeah. So it's going to be your first page for maybe planning. So you'll put who are the parties, what are your premises out of this. And then you'll go to a new page and at top issue, you write the sentence. Leave space, leave blank, space, that's fine, no one's going to penalize you for that. Leave space because you might always remember something and go back and write it. And then you put the law. Where's the law going to come from? From that note I gave you if it's going to be contracts or if you have your own notes for torts. And then you have to apply, meaning you have to take whatever you really copied from your notes in the law section, and don't copy too much because I know that you're copying, okay? I only need to see that you were able to copy only the relevant parts. So you'll have only 3-4 sentences in law specifically on that issue. And then you take them and apply them in the third part, which is application, which means what application? Means that you're going to now take that law, those rules, and apply them to the facts, to the specific issues, to the facts. Now, when you do the issue, look at how they formulated this issue. The issue was, could Colloquy and Mulholland, so they're talking about the people from the question. You see how they were weaving the facts into the issue? The issue is not simply whether specific performance is available. That's not going to work. You might pick up some marks, but look how they did it. You have to put the facts from the question. So, could Colloquy and Mulholland seek an order to specific performance against J.C. Williamson that he carry out his obligations? Of course, it's not a good way actually of doing the issue. There's more to be said because the problem really is not just that, it's also this form requirement. So you have to put some facts in how you write the issue. After the break, I will take you through at least few to know exactly what I want. What did they say? An order for specific performance was not made, and the reason was they would have had to constantly supervise the contract to ensure its terms were met. What are they talking about? So you recall what we said in terms of our tutorial. So if we just go back to this part of the tutorial to see why they said this in this case, we said in order for you to argue specific performance successfully, and by the way, at the bottom of this, it's not about justice, it's about efficiency, economic efficiency, hard-cold efficiency. They're saying the court has to be satisfied that they can supervise this specific performance. Which means what in our case?
5 years of selling slaves.
You have to put someone in the theater, actually, or at least someone to look at certain records, or someone, and is that going to be something efficient economically for the court to supervise? That's not their job, of course. If it were something like selling a pen to bill, would that be the same story? Would the court still think that it wouldn't be efficient? No, it's a one-time transaction. Keep that in mind. Okay. So because there was no note, okay, there could be no action for damages arising from breach of the agreement. What does that mean? They're saying in the comment that they can't get damages. Why can't you get damages? So this is why we went to specific performance, you see. Why can't you get that? Remember we said for you to access equitable remedies, you have to argue that either damages are inadequate or are not available. Now they're telling us they are not available. Why are they not available?
Because there was no actual contract.
Okay, so they're saying that because of that defect, the fact that it's not in writing, it's not witnessed in writing, what would happen?
There's no contract, therefore no damages can be arising.
Okay, so they said the contract does not exist. Yes?
And they wouldn't be able to calculate how much the damages actually are, because the thing is the damages will be based on the price of the commodity and production and sales and stuff like that there, which never even happened.
So that wouldn't come to the picture in the first place, because you have first to convince the court that you have a contract. And we're saying, even though we said that, agreement, intention, and consideration are not issues here, because this will go back and sort of question the existence. The form came back and said, maybe there's no contract here. Let me just go back and talk a bit about something that's also in your textbook. It's worth probably doing so. So this is, I think, from chapter 7. So they were talking here about contracts that must be evidenced in writing. So this is page 199. We'll go back and come back. So here it says, so there are contracts that are void unless in writing, okay? And these include these kind of contracts. And there are contracts that must be evidenced in writing. Okay, this is of course a case from the High Court of Australia. It's from Australia. So in Australia, you'll have 5 classes of contracts that must be evidenced in writing. Okay? To be quite honest with you, I'm not sure where that theater was, but you'll find that there are different acts that will give you different requirements of contracts that need to be evidenced in writing. There are 5 classes basically. So in the exam you have all of this available to you, right? Take the textbook with you just in case you didn't put this stuff in your notes. So you have special promises by executors or administrators to answer for damages out of their own money. That's not the case here. Contracts of guarantee, no. An agreement made in consideration of marriage, no. Contracts for the sale or disposition of land, no. Agreements not to be performed within the space of 1 year from the time they are made, no. So it must be then something about the sale of goods, okay? And you'll find that 2 jurisdictions, Western Australia and Tasmania, that require certain evidence of selling goods over $20. Okay? And then it goes on and talks about what kind of writing is required. Okay? So the idea basically is that there are contracts that must be evidenced in writing, okay? And there are the contracts that must be evidenced, there are contracts that must be evidenced in writing. So this is the second class. It says the absence of writing doesn't affect their validity, but it makes them unenforceable in a court of law. Okay?
So if he'd have done it for the 5 years, it would have been fine. But because he didn't, it's not enforceable.
Excellent point. So Michael is saying, if there was no repudiation, everything would be hunky-dory. They would just continue selling and they would be compensated and that's it. The problem is that Williamson started basically repudiating the contract, so the other party wanted to enforce. And they couldn't. Which means you can't access damages, which means you have to look, instead of common law, you have to go and look for something under equity. That's where they went to this idea of specific performance, which is also something that they failed on. Remember. Okay, let's continue. Excuse me. Let's continue back from 430. Let's look at Lumley and Wagner, or Wagner. 431. From the UK, 19th century. We've seen it before, if you recall, some of you. Wagner contracted to sing at Lumley's theater for a fixed period of time, during which she was not to sing elsewhere. That's our agreement. These are the promises. That's the contract. She broke this promise, i.e. not to sing elsewhere. And Lumley sought to restrain her from singing for another employer. How would you go about restraining her from doing so? You have to go and do what? Okay, and specific performance. You're going to try to enforce the promise that she has made. Okay. The question, was the injunction enforceable? And it was an indirect way of ensuring performance. So this is really specific performance. Okay? We'll talk more about how you fish for issues after the break. So we'll show you how you do the I like what I expect from you. Leave that for now. The decision. While the court could not grant a decree of specific performance, okay, to compel her to sing at Lumley's theater, it could enforce the negative promise not to sing elsewhere by granting an injunction against Lumley, preventing her from singing anywhere else during the term of the contract. Okay? So you can see that these are two possibilities that work as alternatives. You could look for specific performance, and you could look for an injunction. In the previous case, in Williamson, where they failed because the court said, just like they failed here, because I cannot supervise this kind of agreement that I have to go and make sure that she's singing at your and no one else's theater. How can you bring that about back to Williamson? In Williamson, they said, the court said, I cannot enforce this because I cannot just stand there basically and make sure that you are selling this candy in that theater. Yes? Is there a way that you can use injunction there to convince the court that we can work with the negative instead? Instead of trying to actually enforce the idea that you actually sell those candies in that theater, can you look at an injunction from a different perspective? So maybe you can work with something like the court put an injunction on Williamson not to allow anyone else to sell in that theater, for example. Is that going to be easy to enforce or easier to enforce compared to someone who has to look at certain books and make sure that certain payments are made and so on and so forth? Just an idea. Here's that argument here. They said the specific performance wouldn't be easy to administer. So instead we can look at the negative promise, meaning an injunction, saying that the injunction rather not to sing elsewhere. Okay? By granting an injunction against Lumley, preventing her from singing anywhere else during the term of the contract.
What would happen if she did? She would get damages against that can be damages against from her.
Because this is a court order, an injunction is a court order. If you do something that contravenes a court order, you would be open for some form of a disciplinary action. Okay? So the court is going to punish you because you're basically saying, I don't care. So the court would say, because this is an order from the court and you have contravened that order, I will punish you. That's the kind of approach they will take. Okay? There was a similar result in a case called Carrow, where Carrow had entered into contract with Beyond to appear in a television program. Okay. Notice that this is from 1993 now. Beyond 2000, to appear in a television program called Beyond 2000. She then entered into an agreement, you see, to act as a television reporter on another channel and attempted to repudiate her agreement with Beyond. We talked about things like this, about that hole that got burned and the idea that you might have entered into a contract before and after. Something happening here. similar to that. So she entered a contract, K1, that said that she's going to appear for beyond. Then there was K2, after K1, that said that I want now to appear for a different channel. Okay? She's going to be a reporter instead of appearing on that program. That's K2. She can't have both. She can't appear with Beyond and at the same time be this reporter. So she decided to repudiate the first contract. What does that mean, repudiate? So she showed certain acts or conduct that gave impression to Beyond that she doesn't want to continue with that contract. She is not interested in performing her promises under that contract. So where does that leave Beyond? Okay, that's the idea. What can you do if you were Beyond? Okay, so the defendant, meaning Caro, was not being forced to walk by the granting of an injunction. Okay, she could choose to work in some profession other than television reporting that had nothing whatsoever to do with the business of the employer. Okay, let's go to the reflection. The courts will grant an injunction in regards to a contract of personal service, but they will not grant but they will not grant specific performance in respect of the same contract. Why not? So we said that you have to look at this fork of injunction and specific performance. Why would the court give an injunction if the contract is for personal service? So, for example, you came to me and said, I want you to paint me a portrait of myself. I'm the artist. You came to me and said, I'll pay $1,000 for a portrait. You know? What do they call them? Oil-based colors, whatever. Okay. Is this personal service? You betcha, because I am the one who's supposed to do it for you. I'm Picasso. I can't go and give it to someone else and say, yeah, you just do it for him and I will just give it to him. It's personal service. You want me to do it because I'm the best at doing so. So they're saying they will grant an injunction in regards to this. An injunction is in the negative. So you can't do something rather than you have to do something. Why don't you do the same with a specific performance? Can you force me to paint for him this painting? You think the court will actually do the, would the court be prepared to get me to do that painting? That would be the specific performance. What do you think?
Well, I could, but you could just do a really bad painting and give it to them and say, there we go.
Yeah, make a note, please. And if you are listening online, okay, and if you're in Toowoomba, and I hope that you are still actually following these recordings in Springfield, you make a note that this is going to be relevant to part B of the exam. All right. Mareva. Mareva on page 431. A ship owner hired out their ship, the Mareva. Have you heard something called the Mareva injunction or not? Did I mention? No, not. I didn't mention the Mareva injunction. Someone is nodding their head. You didn't mention the Mareva. I've just told you that there are two types of injunction you have to look at. One of them is called the Mareva injunction, and the other one is called the Anton Pillar. Okay, this is the first one. That's where the name comes from. It comes from this case. So the Mareva is the ship that these ship owners are going to be hiring out, and they are going to hire out to an international bulk carrier. Okay, like P&O. So instead of P&O buying the ship, they simply hire the ship for their cruises. Now they agreed that they're going to hire the ship and they're going to pay for it every 2 weeks. So there would be an advance payment every 2 weeks. After International Bulk Carriers was only able to meet the first 2 installments, Mareva sued for damages and unpaid hire. It also sought an injunction to stop the hirers from removing any monies received from the voyage from the court's jurisdiction. So, there's a contract. You are supposed to pay me under this contract. You failed to continue doing so. So I'm going to take you to court asking for damages because of breach of contract. So where's the issue? Where's the problem? In that case, there was a new innovation. And they said, I'm not just going to ask for damages, but I'm also going to ask the court to make an order to stop the carrier from removing the profit, at least the revenue, that they have received from the cruise. Okay? So of course you know that when you go on a cruise, you pay in advance. So all the proceeds from that cruise would be received prior to departure. So that's the money that they're after. So that was new. That was a new idea. Okay? So the issue was basically, was an injunction obtainable to prevent the removal of assets from before judgment? So this is of course assets in terms of cash. Okay? This is back in 1980. Okay? Mareva was granted an injunction. That's why we have the Mareva injunction, which was to continue until the dispute came to trial. So we're going to keep the money in a safe place in this jurisdiction until we decide whether we should give it to the plaintiff or not, or part of it. So that prevented Mareva from disposing of any assets.
Did it prove the postal money?
They have?
Yeah, it just came through.
They approved the postal survey. Okay. Huh? They can go ahead. And the reasoning is going to be given later on. Okay?
So dumb.
Okay? So, that's the difference between law and other things you study at uni. Law is everywhere you go. When you go on the bus, when you go to your apartment, when you flush the toilet. Law is there. Law is always there. It's in the background. But whether you want to talk about it or not, that's the difference. And as you said, sometimes it could be unenforceable even, like a contract, but nothing would happen as long as, no issues would arise, no conflict arises. Anyway, so let's leave that and move on to the anthem pillar order. Okay. No. The toilet flushing is because you have to think, is there a service here? Is there a contract involved in that? Do you think there's a contract underneath that?
Yeah, you pay for your water, you pay for the water supply and sewage.
Okay.
It's not a question, it's a very classical theory that just as essentially living in a society is a social contract. So everything you do is a contract.
Absolutely.
So it's your contract to obey the law in order to not get sent to jail.
Great. But it doesn't stop there. That's where it ends. To some people at least. Now someone once said, and I'm digressing again, someone once said that the human being is a political animal. Who said that?
Is that Socrates?
Thank you. I'm happy that there are people here that are actually as educated as you are. Because he's from New Zealand, you see, that's why. No. But that's the point. Human beings are political animals. You need to understand that. So it's not just about understanding what the law is. The political in that is understanding or arguing at least for what the law should be. You should always think, am I happy with the law as is? That's the political part. Or should I always try to advocate for change in law? Or otherwise? And what change do you want? Not just for the SSM, not just for the burqa. We're talking about anything that you hear about. Some are talking about Islamic finance. And they're saying Islamic finance could be useful in Australia. It might make it easier for people to buy mortgages, even if you are not a Muslim. You shouldn't just sit there and say, yeah. You have to have an idea. You have to say, do I agree with this or not? And why? And you don't want to just pick one and go with it. You have to look at both sides, and you should decide for yourself, not because someone told you on the news or on TV, what would be best for Australia. I'm sorry, but that's the law. You can't take the political out from the law. Anton Pillar. Anton Pillar, thank you for that update. So that's great. Anton Pillar Company was under the belief that one of its agents was supplying confidential information to one of its competitors. So it looks already as something you have seen maybe in one of your scenarios on the assignment. Have you talked about injunctions there? Anton Pillar believed that the agent was in possession of documentation that would prove the breach. So they think they have some evidence in their possession, but they're not sure. So how do you know? So the company was concerned that a subpoena would give the agent, so subpoena means that I will go to court and ask you to produce this evidence. So what would you do? You would turn around and destroy it. Because now you know I'm after it. So the idea was about surprise. You want to make sure that you go and search for it without them knowing first. So it would give them advanced warning of the intention and that any relevant documents would then be destroyed. Of course, the normal practice these days is that you don't wait. See, you just destroy it on regular basis. That's what they do at the moment. Let's look at the issue. Could the company obtain an order that would enable it to enter the agent's premises, to inspect the documents and remove a copy of the relevant information? So what they wanted to do is to use this element of surprise. What is the problem with that? Where is the tension here? What's the course? So the court, how are they going to look at it? They're going to just say, yeah, that's fine, let's do that. Where's the tension now? One party is trying to, get that evidence to show that they have a case against you, but there's also the other argument that you have what? Rights. So rights like privacy, for example. And the court will have to look at, well, which one should trump? Which one should be, which one is more important in this case? That's still the same calculus you'll have to go through if you want to go to court on any Anton Pillar motion.
If you're going to do the Anton Pillar motion as well, how do you go to court? Because you should be versing someone, but you don't want to tell them you're against them.
No, the court is going to look at it. So the court is sitting there, the judge is sitting there saying, that's what you want to get this evidence. And as you say, they are always going to look at, how strong prima facie your case is. But they are also going to have to look at, well, what are the rights of this person that still doesn't know about what we are doing here, but, they still have rights. They don't have to actually, advocate themselves for these rights. The court before giving them the search order, they have to think about that person's rights. Okay? So it's a good point because we are used to this adversarial system. You're wondering, where's the other party? How can they then argue? This is more than inquisitorial. because this is not the trial, you remember. This is not the trial. This is just starting the process towards the trial so I can show you my evidence. So they said, as there was a strong prima facie case, what is a prima facie case? So on the face of it, even though we don't have all the evidence, but I see enough to make me think there is something here. So this is the something, infringement that could cause damage to the applicant. Excuse me. And clear evidence that the defendant was in possession of incriminating material that they would destroy. So they gave them this order. Now, notice how this is restricted. In Australia, it says the anthem pillar order is restricted to intellectual property cases involving trade in pirated and counterfeit goods. Okay? So the evidence is, for example, to get that stuff that was manufactured maybe in China that has Gucci on it. If I go and tell you that I want to inspect these, of course you're going to destroy them. So it has to be through an item pillar. Before you know that I'm coming to get some samples or before I can get some evidence. So it's never going to be available for a general search. And again, why? Because of the calculus between what you want in evidence and what the other party has in rights, specifically in terms of their previous rights. Let's look at quantum merit then. This is probably the important part. Someone had some issues with Sopov in Toowoomba. So let's go and look at Sopov one more time. Bye. So, the plaintiff, builder, Kane, and the defendant owner, Sopov, entered into a construction contract for the renovation and extension of a disused industrial building. So far, so good. The renovations were to be completed in 130 days. However, the works were still uncompleted over a year later due to a series of delays that brought the parties into a dispute. In August 2000, Kane issued a progress claim for the payment of $340,000, to which Sopov responded by deducting liquidated damages and GST. So, in August 2000, Kane, who's the builder, issued a progress claim. You see, this is a divisible contract. For the payment of $340,000, to which Sopov responded by deducting liquidated damages and GST. Why did they deduct liquidated damages? First of all, what is liquidated damages? If you have studied finance, when we say liquidated, a liquidated asset, even accounting, if you say that an asset is liquidable or it's liquidated, or liquidation of assets, you not quite converted into cash, and it's easily convertible into cash. Thank you. That's the same idea with liquidated damages, easily convertible. But here, of course, it's convertible. Why? Because we have something in the contract that says, in the case of this kind of breach, I will be paid this much of money. That's the cash we're talking about. So in the contract, it tells you how much I get paid in the event of a breach. Of course, it has to be reasonable, otherwise it would be a penalty, and then it wouldn't be enforceable. So, why did they deduce these damages? Because of the delays in completing the work. Okay. So, the builder wanted to be paid the full amount. The owner said, no, there were delays here, and I'm going to enforce these liquidated damages. Okay. So the balance that he thought he should be paid, the balance that he thought the builder should be paid was simply $132,600. Less than half. The builder then alleged breach of contract. Why? Because the contract, again, is divisible. I've done that amount of work, and I should be paid that amount of money, and I haven't been paid that amount of money, so that would amount to what? You can think of it as repudiation, because the conduct that he's done here was to pay less than the amount owing, so I'm going to treat that as terminating the contract, and I'm going to turn around and ask for damages. Sopov, so this is the premise and counter premise, responded by alleging that undue delays and purported to co-opt the security under the contract. So he's saying that I shouldn't be paying that amount because of these delays and then the liquidated damages that we have agreed on. So what's the problem now then? So if you say that the contract has these liquidated damages and you're going to say that I would be paid only this amount, is there somewhere else I could go and argue something else to be paid for the work that has already been done? You are burning with a question, I can see.
Yes. Why were there delays?
I don't know.
If the delays were not his fault, and they were the result of stress, or whoever it was.
Sopov.
Yes.
Yeah. So Cain is the one who delayed the work. Sopov is the owner, and he's saying it's your fault, and you're saying maybe it's not.
Yeah. It
Yeah.
depends on what the why there were delays.
Yeah.
What year was it? And what time of the year was it as well? Because it can fly.
Let's look back again at the case itself. From what you see here, what do you think? Whose fault it was?
You would think it would be the builder's fault for not actually doing the job in 130 days. It would take more than 365 days. You would think.
Oh, in August 2000. That's when the thing was finally finished.
But the case isn't
No, it wasn't.
until 2009.
No, it wasn't finished. It was when he gave him the 340,000. That was after the year.
So hang on, the case was brought to the courts in 2009. Isn't there a 6-year limit?
That's what I was thinking.
No. That's the appeal process that reached that point in 2009.
Oh, okay. Oh, right.
So it was a whole back and forth thing until 2009.
Until 2009.
Shit house.
And that's why we taught you what to start with. ADRs. Litigation takes a life of its own. Because they are lawyers. Lawyers are not stupid. Lawyers are not interested in resolving. No, I'm just joking.
Tell me about it.
Strike that out, please. Otherwise, they will strike me out of the rolls.
I've dealt with a lawyer before.
They're lovely people, right? I know. So nice.
Lovely people unless you're working for them.
Exactly.
Anyway to screw you over.
All right. So do you understand now why we're moving beyond that point? You got a certain money paid, but you're saying what? That's not enough.
It didn't cover the costs of what I actually did up to that point.
So what do I do? Where do I go? How can I argue that? You don't go under common law.
Equity.
You can go under equity. Of course, quantum merit is also something you could argue under common law, depending on where it comes from. Remember, this is all based on something called unjust enrichment. So he's saying this Sopov, this owner, got benefit from what I've done for them in terms of my building services, and he didn't actually pay me enough for that. So was quantum merit available, and if so, on what basis? They said yes. Okay. Why? He was the innocent party. What does that mean, he was the innocent party? Back to your point. So when you read, you have to understand what they're telling you. So what does that mean to your question earlier? The court is saying these delays
Weren't his fault.
were not his fault.
Therefore, he can't pay damages or pay anything else. It was beyond his control.
Who's that?
It was the Haiti and the party was.
Who's Cain?
Against the builder.
The builder was coming to court saying, give me more. This is not enough. And they said yes. Why? Because these delays, which Sopov relied on to cut you down, are not your fault. You are innocent. So how did they find that? But when you read, you have to pick up on these things. They're telling you things that are not necessarily given to you in full detail.
In the exam question, will they give us the decision as well, or do we have to come to a decision?
No. So someone is asking the question, how is this question the exam is going to look like? So the first thing you want to do is to go and look at these old exam questions on the study desk. So you remember that at the bottom of this study desk, so if we go back to activity page, at the bottom of this, you'll find 4 previous exams that I've given to you. Okay? Just quickly, so we see why or what you're going to expect on this exam in October. It's all good fun. It's all good fun. So it's going to look like something like this. You know, you have this page. You have this page. Something's going to be different this time around on this page. What is that? It's going to be open. So it's going to be open. Okay? It's going to something that's material at least. It's going to be open. Okay? Now, you'll find something very similar. So you'll find your problem-solving part A multiple choice questions. That's the stuff that we're going through the forums at the moment. And then you'll have a part B. Okay? So that's the kind of question you're going to find. You're given the stub. So what you will find is simply a set of facts. There's no decision. You are the one who's supposed to come with the decision. For example, explain your reasoning. You're going to take the role of the court. Give me a legal opinion. Give me some legal analysis. Who could win or who should win? All right. So let's just go back and continue through those right here. Okay. So they said, and had accepted Sopov's repudiation, giving him the option of either suing in damages for breach. Who's suing in damages for breach? The builder, Cain, or suing on a quantum merit for work done. Okay? So the issue here was basically, which one should you go after? Okay? Should you go after the damages or should you go after the quantum merit? How do you decide which one is best? So they said, in this case, the plaintiff chose quantum merit and the court assessed the amount recoverable on the basis of an amount for profit and costs actually incurred rather than on contract price. That would be better for you actually.
Because he was working for the whole year and not just the 130 days.
And because of this idea of the damages that were liquidated in the contract. So my point from this case is simple. If you get something like this on the exam, I expect you to look at both. Not just quantum merit, not just damages. Try to see which one of those might actually give you more from the court. Okay. So that was the little bit that we wanted to talk about in terms of Sopov. That's the end really of the cases for this chapter. So I'm going to leave it here. Remember, next week we switch gear and talk about something else called the theory of agency, which is a hybrid of torts and contracts. Until then, thank you.